You probably interact with credit ratings way more often than you might think, maybe when a bank's looking at a business loan or you hear analysts talking about a country's financial health on the news. They're basically opinions, right? Expert opinions on creditworthiness. But how much do we really, know about the organizations issuing these really powerful assessments and what actually guarantees their credibility, makes sure they're independent?
That's exactly it. That's the core question, isn't it? In today's financial world, which is just, well, overflowing with information, understanding the basis of trust is absolutely crucial. So today, we're taking a deep dive into the Credit Rating Services Act of 2012. It's a really significant piece of South African law, consolidating earlier efforts into one solid framework.
Okay, so our mission today is to unpack this act. We want to make it clear, engaging, hopefully, whether you're just curious about how finance works or maybe you're a law student needing that deeper dive. We'll look at its purpose, get into the key rules, see where it fits legally, what it means practically for the agencies, and really importantly for you, the investor. And yeah, highlight why it matters in the real world. Okay, let's get into it. So let's start right at the beginning. How does this act actually define a credit rating, and what are credit rating services? Because I think a lot of people just assume a rating is basically a recommendation, like buy this.
You've hit a really, really crucial distinction there. The Act is incredibly specific. A credit rating is defined explicitly as an opinion. That's the key word, an opinion. It's about the creditworthiness of, say, an entity, a specific security, some financial instrument, or the issuer itself. And this opinion uses an established, usually public system of rating categories like AAA or B-, things like that.
Okay, an opinion.
Exactly. And the Act specifically excludes any recommendation to purchase, sell, or hold a security or financial instrument. It's purely an assessment of risk, not an instruction on what to do. That's a fundamental line.
Got it. Assessment, not instruction.
Right. And credit rating services, well, it covers the whole process. The data crunching, the analysis, evaluation, the internal sign-offs, actually issuing the rating, and then keeping an eye on it, reviewing it over time, the whole life cycle.
That exclusion of recommendation feels really significant. Why was drawing that line so clearly such a big deal for the act? What could go wrong if it gets blurred?
Well, it fundamentally comes down to managing expectations and liability.
Yep.
Think about it. If a rating was a recommendation, the agency would essentially be acting like a financial advisor.
Right.
Directly telling people where to put their money.
Mm-hmm. Big responsibility.
Huge. By defining it strictly as an opinion, the Act keeps the agency focused on providing an impartial assessment of risk. It's not telling you what to do. This allows investors, like you, to take that risk assessment and weave it into your own decision-making, your own strategy. You're not just blindly following a buy or sell signal.
Okay, that makes sense. It protects the investor by making them think and the agency by defining its role precisely.
Exactly. Both sides understand the boundaries.
So with that definition clear, why this act? Why was it necessary? What problems, maybe, historical events, was it trying to fix?
The Act's core objectives, they're quite ambitious, and they really do tackle vulnerabilities we've seen historically, especially around, say, the 2008 crisis.
Yeah.
First off, it demands responsible and accountable credit rating agencies. Simple as that. It aims to protect the integrity, transparency, and reliability of the whole process. The ratings themselves, if you can't trust the ratings, the whole financial system starts to wobble, right?
Trust is everything.
Absolutely. And for you, the listener, the investor, a huge goal is improved investor protection. Better information means better decisions. Beyond that, it's looking to improve fairness, efficiency, transparency across the financial markets generally. And perhaps the biggest one, by doing all of this, it aims to reduce systemic risk.
Systemic risk, okay, we hear that term a lot. What does it actually mean here? Is it just jargon?
No, it's definitely not just jargon. It's about stopping a domino effect. Remember 2008, the global financial crisis. A big part of that was triggered by, well, let's say, opaque or even misleading credit ratings on very complex financial products.
Right, those mortgage-backed securities.
Exactly. Things that people thought were safe because they had a good rating, but the underlying risk wasn't properly understood or communicated. That led to a near collapse. This act is, in many ways, a direct response. It's building guardrails to prevent that kind of cascading failure. It's about protecting everyone, banks, sure, but also jobs, pensions, everything tied to the market stability, making sure the information underpinning it all is sound and independent.
So stability and trust on a massive scale.
Got it. Now, who exactly does this act cover? Is every single person in finance affected?
It's broad, but it's also targeted. It applies to credit rating services performed in South Africa. It covers ratings issued by agencies registered in South Africa and basically any person doing these things in South Africa.
Okay.
And here's a really key practical point. Since December 17th, 2013, you simply cannot perform credit rating services or issue a rating in South Africa unless you are a registered credit rating agency under this act.
Wow. Okay, so it's a closed shop unless you're approved.
Pretty much, it's a significant regulatory gate. But it's also important to highlight what the act doesn't do. It doesn't force every single security out there to get a rating. That's not mandated. And it doesn't tell banks or investors they can only invest in things that have a rating.
Okay, so it regulates the raters, not the whole market's choices. Precisely. And another important carve-out. It generally doesn't apply to private credit ratings. If a company hires an agency for a specific confidential assessment just for their own internal use, not meant for public eyes or distribution, that usually falls outside the Act scope.
Right. Makes sense.
Yeah.
So if you do want to be one of these registered agencies, it sounds like getting through that gate is tough. What does registration actually involve, and what are the ongoing duties once you're in?
Oh, it's definitely a rigorous process. It's designed that way
Right.
to ensure high standards right from the start. Agencies have to lay out a lot of detail. How they're incorporated, who owns them, their organizational chart, what resources, financial and human, they have, their whole operational plan, even who they might outsource work to.
Okay, pretty thorough.
Very. And a critical piece under Section 5
Mm-hmm.
is that the applicant company, its directors, its employees, they all have to meet stringent, fit and proper requirements. And this isn't just, ticking a box. It goes deep into honesty, integrity, competence, their operational capacity, their financial stability.
So it's about trusting the people behind the ratings, too.
Absolutely fundamental. The idea is that the judgment itself rests on individuals whose integrity is demonstrably sound. And the authority, that's the FSCA, the Financial Sector Conduct Authority, they have broad powers. They can ask for more info, check with other regulators, really dig in before granting that registration.
Okay, so assuming an agency passes that high bar, gets registered, what's life like then? What are the daily, ongoing responsibilities? This must be where the act really bites in terms of achieving those big objectives like transparency and integrity.
Exactly. The duties are where the rubber meets the road. They're extensive and form the real operational core of the act. One of the absolute cornerstones is independence and integrity. Section 7 is very clear. Agencies have to structure themselves so their business interests, making money, can't possibly compromise their independence or the integrity of their ratings.
How do they ensure that in practice?
Well, the Act even states explicitly that no person, not even the authority itself, can improperly influence or hinder a credit rating or the methodology used to arrive at it. This is vital because if there's even a perception of bias or influence, the rating's value just evaporates.
Right. Trust gone.
Instantly. Then there are strict rules around methodologies and models. This is Section 9 territory.
Yeah.
Ratings can't just be pulled out of thin air. They have to be based on thorough analysis, using methods that are rigorous, systematic, continuously reviewed. And this is key validated based on historical experience. That includes backtesting.
Backtesting. What's that exactly?
It basically means checking if their models actually worked in the past.
Yeah.
Did their predictions of risk line up with what really happened, with actual defaults? Agencies have to constantly review and adapt these methodologies based on this kind of validation. They can't just stick with a model forever if it's not proving accurate.
So they have to prove their homework, essentially. What about telling the public what they're doing? Transparency.
Hugely important. Section 10 deals with transparency in credit ratings. When they publish a rating, they can't just give you the letter grade. They have to clearly state its attributes, any limitations it might have, and provide a clear explanation of the key factors behind it. The goal is so you, the investor, can actually understand how they reached that conclusion.
Not just the what, but the why.
Precisely. And they have to keep monitoring and reviewing those ratings. It's not a one-and-done thing. There's also a specific rule for structured finance instruments. Remember those complex bundles we talked about?
Yeah, the ones from the crisis.
Those. Because they can be so opaque, the Act demands their ratings be clearly differentiated with an additional symbol. It's a flag to say, hey, this is complex, pay extra attention.
A warning label, almost.
Sort of. And here's another powerful safeguard under Section 10. Agencies must refrain from issuing a rating if they don't have enough reliable data, or if the instrument is just too complex, or the quality of information is poor, and it would lead to what the Act calls a non-credible rating.
So they have to say no sometimes.
They must say no. It prevents them from just slapping a rating on something when the foundation isn't solid. It's a crucial market protection.
That's a strong check against just, well, rating everything regardless of quality. What about their internal rules and what they have to tell everyone?
Yes, internal governance is critical. Section 11 mandates they adopt, publish, and stick to a code of conduct. This has to be based on relevant international principles, often looking at IOSCO standards. And Section 13 covers crucial disclosures. Transparency is mandatory, both to the public and their subscribers. This includes their methodologies, how they get paid, their compensation arrangements.
Compensation, too. Interesting.
Yes, and even their historical default rates. This allows you to see their actual track record. How often did the entities they rated AAA actually default compared to B-rated ones?
Wow, that's real accountability.
It is. And there's another vital disclosure, mainly for the regulator's eyes, to spot potential conflicts. Agencies have to tell the authority annually who their 20 largest clients are, and crucially, if any single client makes up more than 10% of their total revenue.
So you can see if they might be overly reliant on or influenced by one big customer.
Exactly. It flags potential pressure points. And maybe one of the most important internal structures is the independent compliance unit mandated by Section 16. This has to be a permanent, functionally independent unit inside the agency.
Independent how?
Well, its officer monitors compliance with the Act and internal policies. They report any problems or irregularities directly to the agency's board and directly to the authority, the FSCA. Crucially, the compliance officer cannot be involved in performing ratings, developing the methodologies, or even be part of sales or setting pay for the analysts.
Total separation.
Total separation. And their own pay cannot be linked to the business performance of the agency.
Right.
It's all designed to ensure they can blow the whistle without fear or favor, reinforcing their independence.
Okay, we've got a good picture of the internal workings now. But you said earlier, no act works in isolation. How does this one fit into the wider legal landscape in South Africa? And, the big question, what happens if things go wrong?
Right, it's definitely part of a bigger picture. What's really interesting is how clearly it connects with other key laws. For example, Section 1A explicitly links it to the Financial Sector Regulation Act of 2017. That's how the registrar role formally became the authority, which we know as the FSCA. This integration helps streamline regulation.
So it's all under one roof, basically.
Largely, yes, for conduct regulation. And importantly, any decision the authority makes that affects someone's rights, like refusing registration or imposing a penalty, must comply with the Promotion of Administrative Justice Act, PAJA.
PAJA, that ensures fair administrative action.
Exactly. It guarantees fairness, procedural correctness, the right to reason, the right to challenge decisions in court. It embeds administrative justice right into the Act's operation. And another link. The Act makes clear it doesn't diminish anyone's rights under the Promotion of Access to Information Act, PAIA. So the public's right to request information under that law remains intact.
Okay, so it plays well with others, legally speaking. Now, you mentioned something earlier that really caught my ear. The Act actually defines plain language. That sounds unusual for a law. How does that affect how ratings are communicated?
It is quite unusual and I think really progressive. Section 1 is clear. Any published info or rating must either be in a specific form if one is prescribed, or, if not, it must be in plain language. And it doesn't just say plain language, it defines it.
Oh.
It says plain language means that an ordinary person, someone with average literacy skills, but also some experience dealing with credit ratings, should be able to understand the content, its significance, and its importance without undue difficulty.
Without difficulty. That's a high bar.
It is. It considers things like the context, how comprehensive it is, consistency, the organization of the information, the vocabulary used, sentence structure, even suggests using illustrations or examples. It shows a real commitment to making complex financial information accessible, not just jargon for insiders. It also specifically allows for electronic communication and storage, keeping it modern.
So clarity isn't just good practice. The law demands it. Fascinating. Okay, shifting gears slightly. Can a local South African agency use a rating from, say, a big international agency? Can they endorse it? And crucially, what if an agency gets it wrong? Is there actual liability?
Good questions. Yes, Section 18 allows for endorsement of external credit ratings, but it's tightly controlled. A registered South African agency can endorse a rating from a foreign agency, but only with the authority's approval. And that approval depends on showing the foreign agency operates under a regulatory system that's basically equivalent to South Africa's. And there must be agreements in place for the regulators to share information.
So you can't just endorse any rating from anywhere.
No. And here's the really important part. The local agency that endorses the rating remains fully responsible for it legally. They can't just say, oh, that was the foreign agency's mistake. If they endorse it, they own it. No passing the buck.
Full responsibility. Okay, and liability if they mess up their own rating, or an endorsed one.
Yes, Section 19 addresses liability directly. It states that a registered credit rating agency may be held liable for loss, damages, or costs that someone sustains as a result of a credit rating or a service they performed in the ordinary course of business.
Wow, so their opinions carry real legal weight and potential consequences.
Absolutely. It's not just an abstract assessment. There's accountability baked in. If negligence or a failure in their process leads to quantifiable harm for someone relying on that rating, they could face significant legal and financial claims.
Okay, that definitely adds a serious layer. So, with all these rules and potential liability, what teeth does the Act actually have? How does the authority enforce all this?
The Act gives the authority considerable powers and enforcement tools. Section 23 outlines the authority's role: supervising agencies, enforcing compliance, and taking steps to protect investors. Their actions have to be consistent with the Act's objectives: integrity, transparency, systemic risk reduction, and they need to consider international standards, act proportionally, and try not to unnecessarily impede competition.
So, a balancing act for the regulator.
A bit, yes. But the enforcement side, Section 32 on offenses and penalties, shows the Act has very sharp teeth. Things like operating as a rating agency without being registered. That's a serious offense. Deliberately making false or misleading statements in relation to ratings, giving false information to an auditor or the internal compliance officer, also major offenses.
And the penalties?
They are severe. We're talking about a substantial fine or imprisonment for up to 10 years or potentially both. This really underscores just how seriously the legislation takes integrity, accuracy, and compliance in this critical part of the financial system. It sends a very strong message.
Wow, 10 years. That's significant. Okay, we've really covered a lot of ground here on the Credit Rating Services Act 2012. From nailing down that a rating is an opinion, not advice, through the tough registration hoops, the vital importance of independence, and that compliance unit, all the way to serious liability and penalties. It really does seem like a comprehensive framework aimed squarely at building and maintaining trust.
I think that's exactly right. It's a clear statement that even in these highly specialized, complex financial markets, the fundamental principles matter: accountability, transparency, protecting investors. These are non-negotiables.
Yeah.
It's all about trying to ensure the financial infrastructure has reliable information at its core, and that the providers of that information are held to incredibly high standards.
So, thinking back on everything we've discussed, what really stands out to you? Maybe it's that specific, almost dare I say, revolutionary definition of plain language actually written into law. A reminder that clarity has to be central, even when things get complex. Or maybe it's just the sheer weight of responsibility on these agencies. Knowing their opinions aren't just opinions, they have real-world impact, backed by legal liability and the threat of serious penalties. It's a framework that fundamentally shapes how we all perceive and interact with financial risk. It really makes you wonder what other areas of financial regulation deserve this kind of deep dive.